Hi, welcome to our webinar. I'd like to hand it over to our students to give a brief introduction, and then we will introduce everyone more broadly.
Hi, everybody. Thank you so much for coming. My name is Leora Krancer. I'm the co-president of the American Constitution Society chapter here at UCLA, and ACS is the foremost progressive lawyering network in the country. And since tribal sovereignty is very important to both me and progressive values in general, I thought that this would be a great event to have, considering how water scarce our region is, how important water is to tribal communities, and as a way to kind of marry the different progressive interests that may be affected by or interested in this topic.
Hi, I'm Ashley Anderson, a co-president of NALSA, and we decided to co-sponsor this event because we wanted to raise awareness for this upcoming case for our members. NALSA is the group that is for Native students and future Indian law practitioners, and water is life. So we're really excited for everyone to be here and to debrief for us the oral arguments that just happened.
Thank you, Ashley and Leora. Welcome to our panel, debriefing the U.S. Supreme Court's oral argument in Arizona versus Navajo Nation that was heard on Monday. This program is hosted in partnership with both the American Constitution Society, the Native American Law Students Association, and the Native Nations Law and Policy Center. My name is Lauren Van Schilfgaard. I'm an assistant professor here at UCLA and a member of the Cochiti Pueblo. UCLA acknowledges the Gabrielino Tongva peoples as the traditional land caretakers of Thavangar, also known as the LA Basin and the Southern Channel Islands. As a land grant institution, we pay our respects to the Hunukfutum, or ancestors, Ahihirom, elders, and Iohinkim, our relatives and relations past, present, and emerging. I am extremely honored to introduce our esteemed panelist and moderator for today's debrief. Professor Ezra Rosser is a law professor at American University and is author of the incredible book, A Nation Within: Navajo Land and Economic Development. His research focuses on poverty and tribal economic development. He's a co-author of Poverty Law, Policy and Practice, co-editor of the Property Law Canon, exploring the major cases, and of Tribes, Land, and the Environment, as well as editor of Holes in the Safety Net, Federalism and Poverty. Professor Rosser joined a brief of law professors in support of the Navajo Nation in this case. Professor Heather Whiteman-Rensham is an enrolled citizen of the Apsulaga, or Crow Tribe of Montana. She is the director of the Tribal Justice Clinic and associate clinical professor at the University of Arizona Rogers College of Law. She also teaches courses on tribal water and law, tribal courts, and tribal law. She previously worked as a senior staff attorney at the Native American Rights Fund in Boulder, Colorado, focusing on domestic and international legal advocacy on the rights of Indigenous peoples to water, land, and self-determination. Professor Whiteman-Rensham also served as joint lead counsel for her own tribe on a wide variety of legal issues, including the final phase of negotiation and approval of the Crow Tribe's water rights settlement, as well as preliminary implementation of the settlement. She wrote the amicus brief for tribal nations and Indian organizations in support of the Navajo Nation with NARF and the Native American Law Center at the University of Washington School of Law, as well as the University of Idaho College of Law. Finally, Professor Matthew Fletcher, a member of the Grand Traverse Band, is the Harry Burns Hutchins Collegiate Professor of Law at Michigan Law. He teaches in rights in the areas of federal Indian law, American Indian tribal law, Anishinaabe law, and political philosophy, constitutional law, federal courts, and legal ethics, amongst many other topics. He also sits as the Chief Justice of the Pikagan Band of Potawatomi Indians and the Porch Band of Creek Indians. Most recently, Professor Fletcher wrote 2 articles, a case preview and an argument analysis for this case on the SCOTUS blog. Both of the articles are linked on UCLA's Native Nations Law and Policy events page for this webinar, as well as on Turtle Talk. And finally, our esteemed moderator, Professor Micah Lorandi, is Dene and is the San Manuel Band of Mission Indians Director for the Tribal Legal Development Clinic here at UCLA. She previously served as the Senior Attorney for the California Tribal Families Coalition. She was also a staff attorney at the California Indian Legal Services, domestic violence attorney at the Navajo Nation with the Dene People's Legal Services, a deputy prosecutor with the Gila River Indian Community, and a guardian ad litem at the Salt River Pima Maricopa Indian Community. So as you can see, we have a vast and deep experience of Indian country and legal issues to help us make sense of what is going on in this case and the massive stakes that are on the table in this potential litigation. And so with that, I would like to turn it over to Professor Fletcher.
All right. I hope you can hear me. Thank you for inviting me. I'm a last minute replacement. And so I come wildly unprepared. But luckily I can speak on a high enough level of generality so that hopefully I won't mess it up too bad. So this case is about the Navajo Nation's water rights. And there are many sources of water in and near Navajo, but there's not anywhere near enough water. Many of those sources of water are relatively insignificant compared to the main stem of the Colorado River. Many of those sources of water have either been settled and apportioned to, at least in part, to the Navajo Nation, but the main stem has not and never has been. So the Colorado River is subject to a series of court decisions going all the way back to 1963 in a case before the United States Supreme Court in its original jurisdiction called Arizona versus California. And the United States back in the 1950s, this is a really important period of time in American Indian law and policy. It was the termination era. Congress was in the mood for ending all of Indian law. And the Department of Justice is an exuberant enthusiastic supporter of such a proposition. I use those words very carefully and also intentionally in the present tense. Do not trust your trustee, as the source saying goes in Indian country. In 1950s, the United States did everything it could successfully, I might add, to exclude the Navajo Nation from the litigation involving the main stem of the Colorado River. The reason for that, of course, is the Navajo Nation is the biggest thing going in the area. That is not a state government. It is enormous and has potentially the amount of water that is owed the Navajo Nation as a function of federal Indian law, and its treaty is potentially the size or exceeds the size of states. So that leads to my second point, which is the question is what law applies here? The Navajo Nation is asking at this point a very limited question, which is should the United States actually assess the water needs of the Navajo Nation and develop a plan? That plan may or may not include water that could be apportioned from the main stem of the Colorado River. As we've noted before, Navajo is not a part of that apportionment. They've been excluded over their objections on that question, so it remains to be seen if other water could actually be, other sources of water could be sufficient, or are we talking about the main stem? So the law on water in the West derives from a case called Winters versus United States, which is a case that arose in Montana and Idaho. And there the Supreme Court held in 1908, I guess, that Indian tribes that in the West in particular, that are the beneficiaries of a treaty that establish a reservation are also entitled to water, sufficient water to fulfill the purposes of that reservation. And I haven't gone back and reread Winters. The actual language of the Supreme Court's opinion, as always, is very important in this case. But that's the general rule. When a tribe enjoys a reservation, it also has an appurtenant right to water as a result, even if the treaty doesn't say, or the statute that creates the reservation doesn't say anything about water. So that's Winters. Secondly, another big area of law is at issue is the law of the breach of trust. So the Navajo Nation here has brought a breach of trust claim against the United States. They're not suing the United States for money damages. We know that is a very difficult thing to do. Tribes don't generally win money damages, breach of trust cases against the United States. But what the tribe is suing here for is an injunction ordering the United States to take an action that it apparently does not want to do. And those, well, actually two actions. Those actions are to assess the needs of the water of the Navajo Nation and develop a plan, and perhaps later on spend money to create, help to create additional infrastructure for water on the Navajo reservation, and perhaps even re-adjudicate or reopen older cases and find sources of water for the Navajo Nation to access. But those last two steps are a future case if we get to that point. So the law of the breach of trust is a difficult one. In terms of money damages, there is a federal waiver of sovereign immunity that allows Indian tribes to sue for breach of trust. The waiver itself is called the Tucker Act. It's very simple. You could sue the United States for breach of trust for money damages. It doesn't say breach of trust in the text, but it is about suing the United States for money damages, and trust breach claims go into that statute. The Supreme Court has imposed a gloss on top of the text of the statute that protects the federal government in additional. That gloss is that the tribe must identify a substantive source of law that establishes an obligation on behalf of the United States to a monetary obligation on behalf of the United States to pay off in the event that there is a breach of a fiduciary duty. So you got to find a source of law that either explicitly or implicitly is an acknowledgement that the United States owes a fiduciary duty on a particular question. So the fight, and the fight has been going on for decades now, is the Department of Justice litigating position is that source of law must be explicit, almost the equivalent of something like you might say a clear expression rule or clear statement rule. Whereas the tribes and the lower courts have been very clear that you can imply from the text of the statute or the structure of the regulations in the question at issue that you could imply a fiduciary duty. And Department of Justice for many years has been looking for a vehicle to get the Supreme Court to say, to adopt its litigating position, which it has always adopted, which is you must find an explicit understanding from Congress, sort of like gold standard language. Congress says, we accept a fiduciary duty, full stop. If you see that in the statute, then there's a fiduciary duty. From the Department of Justice perspective, if you don't see that, there isn't one. This isn't a money damages case, though. This is just the tribe suing to force the United States to do something. And that's close enough, at least from the Department of Justice position, to say that if the statute or the treaty doesn't require the United States to take an action, it is not obligated to do so. And the Department of Justice additionally adds, and Supreme Court or Article 3 courts, if you tell the Department of Interior to do this work, you are violating the separation of powers and creating a constitutional crisis. So looking back and trying to figure out what else I should add to that. I should add sort of the overarching thing here, and then I'll turn it over, is this notion of the law of the river. Starting in 1922, I understand that Congress, several states, 7 states, I believe, and the United States, and 25 Indian tribes who were represented effectively by the United States beginning in the 1950s have adjudicated and continue to adjudicate under the Supreme Court's original jurisdiction, the law of the river. All of the water in the Colorado River and its tributaries has effectively been appropriated to various water users. And so if there is going to be the reopening of much of the question of apportionment, a redivision based on the Navajo Nation and the Department of Interior reaching a conclusion that Navajo is entitled to more water down the line in the future, we probably would have to reopen the case and the decree in Arizona versus California. At least that's the perspective and the position advanced by the Department of Justice and 3 of the states and some other water users. To do so is impossible, according to those parties, whereas we don't know the answer to that question yet from the perspective of the Navajo Nation. And I'll leave it at that. And also, I want to add, it is a delight to be on Zoom with Heather and Ezra, who are longstanding colleagues. Heather, I will have to point this out, is one of the few law professors. I count myself in this in this group that has actually worked in-house for an Indian tribe. And I like to think that we have a special set of Jedi skills that arise from that experience.
Great, thank you, Matthew. And likewise, it's a pleasure to be on a panel with Ezra and Matthew. Yeah, so I guess I'll start off talking just a little bit more, expanding a little bit on what Matthew's already said about the Winners Doctrine. Winners is another pronouncement from the United States Supreme Court 115 years ago in 1908 that addressed a lack of water security on an Indian reservation, not so different from the situation that the Supreme Court is examining today. In that case, the United States brought suit on behalf of the tribes of the Fort Belknap Reservation in Montana. In that particular case, the United States was acting to preserve and protect the water interests of the tribes. And what they sought to do in Winners was to stop non-Indian water users on the Milk River upstream from the Fort Belknap Reservation from using all of the water in that river to the extent that there was not enough water left to support agriculture and other uses on the Fort Belknap Reservation. The Supreme Court in that case ruled in favor of the tribes and the United States and supported and established that water access was critical, and that when the United States and an Indian tribe agree to set aside an Indian reservation to establish a permanent homeland for Indian tribes, that there is an implied right to enough water to fulfill the purpose of the reservation going forward for a permanent, viable homeland. The implication of water in the establishment of a reservation really seems like a matter of common sense. We've been saying for a long time in Indian country now that water is life, and that our access, our rights to water are absolutely critical to our ongoing survival, to our human rights, to our collective rights as Indigenous peoples. The purposes for which our homelands are established absolutely require water. There's no way around it. In this case, the Navajo Nation's homeland was established pursuant to treaties, and I think that's a really important element of the case and the questions that are the focus of defining what the United States is obligated to do. But I want to also underscore that water rights establishing a water right doesn't necessarily require a treaty. The United States Supreme Court in Arizona versus California in 1963 also found that those tribes that don't have a treaty also have a water right in association with the establishment of their permanent homeland. So some of those reservations are established through very, very short documents, very terse language, sometimes just a sentence or two, but the implied right to water has been found to have been established through even the most minimal of recognitions that there's an intent to create a permanent homeland. And I think that's really important. Another element of winners' rights that I think is really critical to keep in mind is that, again, in Arizona versus California, the United States Supreme Court recognized that winners' rights vest on the date of the establishment of a reservation. In other words, they exist and they need to be quantified and defined, but that is a legally vested right as of the date of the establishment of the reservation. So it's an important legal component, I think, of winners' right that really should drive some more equitable discussion about what settled expectations are, because there are vested rights in existence, and our settled expectations should be realistic and should acknowledge those vested rights of Indian tribes to water. I think that it's also important to talk about the importance of the Winners Doctrine over the past 60 or 70 years since Arizona versus California was decided. As the United States came out of the termination era and began to work on a more cooperative basis with tribal nations, defining and protecting water rights of tribes has been a focus since at least the 1970s of certain departments within the federal government who have set out criteria and processes through which tribal water rights are examined, determined, quantified, sometimes settled, and also looking at ways through which the federal trustee can work with tribes to establish infrastructure to bring water to beneficial use on Indian reservations and improve the quality of life and the viability of the homeland. Those programs are really important, and their basis is on the Winner's Doctrine. So I think it's important to underscore that the legal foundation provided by the Winner's Doctrine to Indian tribes in getting the federal trustee to do what it should do is critical. For over a century now, the Winner's Doctrine has been important as far as providing a path to achieving certainty for both Indian tribes and the surrounding communities with respect to water resources. It supports and provides a legal incentive for the federal trustee to negotiate water rights settlements and for Congress to fund them. So both the executive branch and the legislative branch of the US government have been required by the Winner's Doctrine or have been supported by the Winner's Doctrine in bringing water to Indian communities. So Winners has been critical in that respect. Non-Indian stakeholders likewise have relied on the Winner's Doctrine and have benefited from its fulfillment in Indian communities, because as we know, when Indian tribes have enough water, economies are built, federal infrastructure funding provides benefits to non-Indians all over the American West as well as Indian people. So the impact of the Winner's decision is immense, and its significance to the fulfillment of basic human rights in Indian country can't be understated. I'll leave it at that for now. Ezra.
Great. So thank you so much. And just to introduce myself, I am a non-Indian, and the Navajo word for it is Bilagana, which was translated to me as white, the other, or the enemy. And that's a fair description. And I should also note in the participants list, I saw lots of people who know much more than I do on this topic. So Stanley's in one of the callers in, as well as Paul, Trevor, who wrote a great brief, Herb Yazzie, and Heather, who wrote a brief I'm going to talk about in a second. I actually think that this, and we get this, I think, from both what Matthew and Heather were saying, it's not that complicated, the case. It's, does the United States live up to the Winter's Doctrine or not? And what do you do with the complications of the Navajo Nation 1, Navajo Nation 2, and Hickoria connecting to the Winter's Doctrine? And so the brief that I wrote with Dan McCool and David Wilkins focused on the treaties. And on the treaty part from the Navajo side, of course, it's good to remember that the United States engaged in a scorched earth campaign that did, among other things, poisoned wells as a way to starve out the tribe, forced them on a long march, and then interned them for 4 years while they tried to relocate. And then when Sherman came in, Sherman too tried to relocate the tribe, and the tribal elders and leaders said, no, we want to return to our homeland. Eventually, that is what happened. In the oral argument, there was a lot of discussion about whether it was a unique treaty or not. I think the clear response, one of them, is that it is certainly a unique treaty from the standpoint of Navajos, as well as the history of the expansion of the reservation that happened afterward. And so one of the challenges that's was in the oral argument was a lot of focus just on the original 1868 space, but the reservation expanded all the way to the river, and it's worth keeping that in mind. Now, in the deep dig amicus brief, you have a lot of the facts, and this is the one Heather at Utah wrote with others. There's a lot of the facts about the nature of water needs on the reservation. And so, as they point out, roughly a third of families are forced to purchase bottled water, haul water long distances, or use contaminated water to meet their basic needs. They're much more likely than non-Indians off reservation to live without water or without reliable water. It's also much more expensive because hauling water is expensive. You have to pay for the gas. It's also expensive in terms of time. Again, my perspective is that it's not that why we have this problem is not that complicated either. We have basically decided to give a lot of water to non-Indians. One of the things that came up in the oral argument was the discussion about, is this about infrastructure or not? What's the US's obligation? But the comparator is not do this thing for Navajos or not do this thing for Navajos. I think the comparator is the Central Arizona project, which dumps tons of water, put up and necessitated the building of entire power plants to bring that water long distances so that non-Indians could inhabit a desert in southern Arizona. And so there is, I think, a degree to which this was focused on Navajo, but the larger story of it is that Navajos have water under winters and under the treaty that have been neglected as we pursued other forms of development. I'll stop in a second. Let me say about the case itself. One of the challenges is that even though it should be a straightforward case, that was also true of Navajo Nation 1, where the bad actions involved in were denied by the Supreme Court for damages. I think it's hard to think of actions that were more problematic from the perspective of a trustee than we had in Navajo Nation 1, and yet the Navajo Nation lost in those cases. And then finally, I think one of the other challenges is how much does the United States know that the Navajo Nation needs water? And it's not so much in the briefs, but livestock reduction, which happened during the New Deal, was a period in which the United States had plenty of reason to know about the needs of the Navajo Nation for water, and instead chose to dramatically undercut the wealth of tribal members by killing their animals. So I don't see this as a complicated legal thing. I see this as largely a social problem with a legal angle. And the social problem is that we simply don't care about Navajo water relative to non-Indian water demands. And that, I would say, is the Western water users amicus brief, as well as many of the Alito questions in the oral argument, was a point that if Navajos got water, look how it would harm non-Indians. My response to that is we've done plenty to help non-Indians. It's time to do a little bit more for those with the vested right. So I'll stop there.
Thank you so much to our panelists. I know Professor Fletcher had mentioned that he was not prepared, but that was excellent. Excellent. Thank you for sharing all of that. A couple of things that I wanted to kind of start off with, and we talked briefly a little bit more about, generally what had happened and some of the discussions. And maybe we can just, before we dive in generally as to positions or feedback on the oral arguments. Professor Rosser, you kind of led us into one of the grid questions. Justice Alito was very much hung up on this idea of real world consequences of the court's decision, and really harped on how a ruling in favor of Navajo would be a windfall, very much leaving states struggling to find any water. I'd like to hear a little bit more. Professor Rosser, you did share your position, but any other response on the focus of how this would be unfair to non-native water users?
Oh, I can. Is this open for any of us? I got a couple of points. One is, this is a textualist court, and conservatives talk about how they're judges, umpires calling balls and strikes, but the only thing that allows for the United States to win this case is the policy question. So that these are policy judges. The ones that are going to rule against the Navajo Nation or vote against the Navajo Nation in this case are more interested in policy questions. The second is that this is an unbelievably racist question. It harkens back to Justice Alito's use of the phrase, the only family this child has ever known, an adoptive couple versus baby girl. The non-Indian family is a family. The tribal member family, the Cherokee family in that case, they were not real people. Here you actually have Justice Alito saying there's the real world and then there's Navajo. The real world is the world of the state of Arizona, state of Colorado, and state of whatever the other state was that signed on to this terrible case.
Yeah, I just wanted to add a little bit to that. I think it's a really important point when we think about the bias implicit in some of the questions that are asked about what happens on the ground, right? What happens on the ground means that we are concerned about the impact of water instability on non-native communities and the lack of certainty and how that distresses, again, non-Indian water users. And the concerns about water availability are important, but they shouldn't be used to prevent tribal nations from being able to fulfill their rights. What is happening on the ground in the Navajo Nation? I mean, we had a few questions about that from the justices as well, which I think brought forth some of the really stunning moments during the oral argument, where numbers about per capita water usage that currently is feasible on the ground today seem to be really stunning. And you would hope that those would catch the attention of some of the justices that maybe aren't quite sure where the equities lay or where the policy concerns go. And at the end of the day, I think it's really important to note that recognizing the water rights of the Navajo Nation, or recognizing a duty on the part of the federal government, which is really what the case is about. It's not about a quantification. It's about what should people be doing to change an unacceptable situation on the ground today. That isn't going to address water scarcity. What's going to address water scarcity is changing course in ways that pay attention to real science and acknowledge, the increasing scarcity of a resource that everybody needs to depend on, and have a path towards fulfillment of their rights to it.
Professor Rosser, do you want to add anything?
Just from a technical part, they're not actually asking for that much, right? So the posture of this case is a relatively minor ask that should be straightforward. We want you to figure out how much water we have a right to and how you plan on dealing with it. And even that is getting a major pushback. So I think that shows that if they were to ask for the much bigger things that the Western Water Brief is all a scare tactic about, then there'd be even more. But here, that bare thing that you would think would be a simple, how much water do we need to make this a space viable, that I would say would be automatically done if they were non-Indians. Even in rural areas, non-Indians, you think about what happened in Tennessee Valley. Infrastructure happens. When Indians ask for it, it's blocked.
Great, thank you. Professor Fletcher, in your case analysis of the after the oral arguments, you had written that Justice Barrett seemed to be a deciding vote. And I think there's a lot of folks who have been providing feedback about how she might be a deciding vote. And in her questioning, she seemed to really be focused on this breach of trust or breach of contract distinction, really trying to figure out the two. And it sounded like she was really trying to square Winters with the Hickory case. Can you all provide any clarity there, or any feedback, or anything that you want to add about Justice Barrett's line of questioning?
Yeah, the first thing I will say is a little bit of a disclaimer. When you're writing for SCOTUS blog, they like to see that there's a swing justice, that there is actually, this isn't going to be a complete blowout for one side or the other. So I talked to a few people, and I agree that Justice Barrett seemed to be in her questions looking at both sides of the question. That doesn't mean that has no indication whatsoever on how she's going to vote. She's just curious. Maybe she's just curious. I don't know. Maybe she really is considering this question. Maybe she really is the swing vote. I'd say as a general matter, she kind of is a swing vote in Indian law questions. But really what I think is happening, and this answers another question that's helps to answer your question, another question in the Q&A, which is what are we talking about when we say, is this a treaty case, or is it a bare trust case? So the government opened up by trying to use the metaphor of the bundle of sticks that many of us in law school learn in property class. Everybody gets when you get a parcel of land or a piece of property, you have a bundle of sticks. And, for Indians, for example, that are doctrine of discovery, the bundle of sticks that you get, you do everything you want with the land. You just can't sell it to anybody except the United States, which is a big stick. So that's what the government is saying. So this is a property rights question, and that they're trying to limit what Indian tribes acquire when they acquire an Indian reservation. And so Winters says one of the bundles of sticks is the right to water. The federal government is trying to frame this question as that is all it is, a right to water. So the United States obligation ends at the moment the treaty is signed. If there is water that you can access, Navajo, the United States is saying, then go ahead. It is your water. Do your thing, unless, you know, the United States Supreme Court or somebody comes along and takes it away as a virtue of, you know, Arizona v. California or something. But the government's position is that you, tribe, can make us, the United States government, do nothing that we otherwise are not going to do. And so if this case is construed as a trust case, then the United States is probably going to win the case. If this case is construed as a treaty rights case, then Justice Barrett had probably the best question for anybody that is interested in hoping tribes win in this case. The question is, if this is a contract case or a treaty interpretation case, then we have to look to the expectation of the parties. That's what you do in treaties. You look to see that, in particular, the expectation of the tribe. Treaty terms are to be construed to the benefit of the tribe. So if that's the case, the United States loses hands down. And the reason the United States doesn't want this to be a treaty interpretation / contract breach case is because the way the Supreme Court has characterized the Tucker Act cases is that the expectations of the tribe are fundamentally irrelevant. The only expectations that matter are the United States expectations. And if that's the kind of law that is imported into this area, it really chisels into treaty interpretation cases in a fundamental way. You can't actually sue the government to enforce your treaty rights if that's the case.
Anybody else want to chime in?
Just a quick thing on what Matthew brought up about the bundle of sticks. I thought that was an odd part of the whole argument, was this focus on the bundle. And, you know, one of the things that it's an unrealistic optimism on it, my part, but the bundle also cuts against the United States in some ways too, if the water rights are treated as a part of the bundle that the tribes got. And so, you know, I had thought, you know, and the reason I say it cuts against is that in takings cases, the Supreme Court cares a lot about no bundle, right? So there's this one about a coaxial cable. You can't even put a coaxial cable on somebody else's land without it being a taking. If water is part of the bundle, then if the government functionally takes it and gives it to Phoenix, that should be a taking from the Navajo. So I don't think it'll do anything in this case, but it doesn't, it's not a straightforward that this analogy to the bundle works on the side of the US, which is why I thought it was odd that the US attorney was bringing it up in that way.
Yeah, and just to add a little bit to that, I guess I was struck by that analogy as well, because it really ignores the nature of water and what a water right is. It's not like other property rights, right? Water is fluid, right? What other oxymorons can I come up with? But, you know, the right to water is a right to use something that moves and conveys itself away from you if you don't use it, right? It's not like timber that is static or land that is static. Water is sort of unique in that way. And so to characterize it or to try and manufacture limitations of a water right based on, you know, some of the different limitations on recovery for damage to resources that are static and really different in their nature, I think didn't work very well for me. And I'm not sure that that will be a helpful analogy that, you know, the United States asserted in its oral argument, because it really doesn't fit well with the way that water is utilized, the way that water is allocated, and how the law treats water. Another thing that I think was frustrating to hear were the repeated assertions that there's plenty of water for the Navajo Nation to use. They just need to drill wells. Really difficult to accept that when we have well-documented studies about the nature of the water under the ground in a lot of areas in this region where there's natural characteristics of the water, like arsenic, that can make water unfit for human consumption, as well as pollution of water from things like uranium mining activity over the, you know, more recent decades. So asserting that everything's fine, they can just drill some wells and their needs will be met is really disingenuous. I think that the United States knows that. So the fact that they were making those arguments, those assertions, was incredibly frustrating to hear.
Another frustrating aspect of the federal government's argument was generally that winters does not create a judicially enforceable duty. How can you have a right under winters and not have a duty?
I think we're all going to just agree with, oh, sorry. Go ahead, Matthew.
Well, I can try to explain because I've sat in a room with Department of Justice a lot of times trying to have them explain that to me. I think the position is it's a separation of powers argument that the United States might enter into a contract with somebody, but they're still immune from suit. Just like when an Indian tribe enters into a contract and doesn't waive sovereign immunity in the contract. Treaties don't waive sovereign immunity. Congress waives sovereign immunity, at least federal sovereign immunity. So the Tucker Act, the Administrative Procedure Act, those are waivers of sovereign immunity, the Quiet Title Act. And the thing is that they're really broad waivers of immunity. The Administrative Procedure Act basically allows anybody to sue the United States for like 6 years for arbitrary and capricious actions. So the United States has decided affirmatively not to do anything in relation to the relief that Navajo Nation wants in this case. So they're suing under the Administrative Procedure Act. It's a really routine thing. The problem is that in addition to the separation of powers issues, the Department of Justice still views the federal tribal relationship as a guardianship. And, Dan Raybear, who is here today, has actually documented and participated in some of these cases where DOJ attorneys have been sanctioned for asserting like the rule of law is Lone Wolf v. Hitchcock, 1903. A guardianship is one in which the ward has no rights to challenge the decisions of the guardian, whereas a trustee, a trust beneficiary does have the right to sue the trustee for a breach of trust. And, Department of Justice litigating position is that, no, we're still in a guardianship position. And we make a choice. It's, in the United States, take a choice. There's no questioning that. And if you put an additional gloss on top of guardianship on top of the separation of powers thing, then you have Lone Wolf v. Hitchcock, which allows tribes no opportunity to challenge any of the actions of the United States.
I was just going to add that many of the questions in oral argument were in line with your question, right? Some of the justices were pointing that out, that one only has meaning if the other is also true. And so I think your frustration was shared by some of the justices now, maybe not a majority, but it certainly came out. And I thought they did a good job bringing out that argument and helping along the attorney.
I think sorry to keep jumping in, but I think one really interesting possibility, I love that Navajo Nation's position in this case, which is really the acknowledgement, the creation of fiduciary duty is when the United States forcibly stepped in the shoes of the Navajo Nation and asserted rights in a way that was deeply prejudicial to the position of the Navajo Nation, but did it more than 60 years ago. And that's absolutely an assumption of a fiduciary duty when you jump in the shoes of your trust beneficiary and force them and on their behalf supposedly take a position. That is a fiduciary duty by definition. And we'll see if a majority of the Supreme Court cares at all about the law of trust. My guess is they do not.
I was encouraged by the line of questioning from a few of the justices, especially the newer justices, and their inability to accept the assertions set forth by the federal government as far as what the nature of their trust and what their duties, if there is a duty at all, basically, and how that's tenable under any reading of, and any characterization of the relationship between the federal government and Indian tribes. So I was encouraged by the lines of questioning by a few of the justices on that end, I will say.
Definitely, kind of jumping to that. At the end of oral arguments, Justice Jackson really kind of asked about the decision and, what would this decision from the court end up looking like? And she asked, whether or not the U.S. actually breached the duty to the Navajo Nation. In her line of questioning, I think it brought up the bigger question for everybody here. And I see some of the chat questions coming up is like, where are we procedurally? What happens if this is a remand to the Ninth Circuit? What happens generally with a decision from the Supreme Court?
Well, what happens in the real world is that the Supreme Court usually doesn't know how to remand cases properly to the lower court and they botch it. But I think what happens is the tribe gets to amend its complaint and raise and actually litigate the question of whether there is a duty of the United States to do the things that Navajo wants. I mean, that's actually at a very early stage. And to answer the question about why we're talking about the merits of the case is that when you ask to a federal court to amend your complaint to include something, you have to have a basis. So if there's any basis whatsoever for the Navajo Nation's breach of trust claim, they have to allow for the amendment of the complaint. So that's all this is. Is there even a little bit of an opportunity for the tribe to raise this claim? That's where we are. And it seems like at least 4 justices are like, you can't even be in court, let alone actually try to make a claim about treaty rights.
And I think that we don't know what the court's going to do because it could take it much further than the posture in the case. I think the risk is that they extend Jicarilla Navajo 1 into Winters, and the briefs that were done and some of the questions when the court kept asking, is there anything unique about the Navajo Treaty, or is this the same as all the others? That was feeding straight from some of the amicus that were saying, if you do this, it'll open up all sorts of challenges in other cases. Don't do it because that'd be horrible, right? So I think the risk is that they come out with a decision that just cuts off a lot of the cases at the knees, even though theoretically this should be a pretty simple back with a minor direction. But they don't take cert for that reason.
Can I just add a couple more things? In line with what Heather said earlier about arsenic, I think there were 3 answers the Department of Justice made to questions that indicate the true viciousness of the United States in this case. Number 1, the whole thing about groundwater. Hopi has litigated for years against the United States to try to help them get access to water. They have arsenic in their water. I've been to Hopi. You've got to bring your own water. It's ridiculous. This is the United States. We should have water. And the U.S. position is like, go dig your own water. Number 2 is that they say Justice Gorsuch's Act. Well, what if the Navajo Nation tries to reopen Arizona v. California so they can get some main stem water? And the United States position basically is like, well, they could go ahead and do that. And Gorsuch asked the right question, which is, but you're going to oppose that just like you did in 52. And the answer to that was, well, we'll think about it. And that's just an utter absolute lack of candor to the court, to be clear. And there was a third thing I was going to complain about, but I forgot what it was.
Okay, so thank you for all of those. Those are my generally moderated questions. Before we jump to participant questions, I just wanted to get your general sense or anything else that you wanted to talk about that you thought was important, any questions that you thought were very relevant, and or anything that you wanted to highlight from the oral arguments generally.
I think we've already run through most of mine, but I think it is striking that the posture of this case has raised the concerns of the lower basin states in a way that they're weighing in ways that are completely unhinged, I think, in some ways, and really disconnected from what this case is about, which is water security for an Indian reservation, and that preventing Navajo from moving forward with their case against the United States, trying to get them to do something, right? Just begin to do something, isn't going to solve the problems of the lower basin states, but that, recognizing tribal nations as stakeholders who should have an active role along with non-Indian communities and the lower basin states in managing water and finding ways to conserve water and allocating water in ways that might be more equitable in the future. That's critical, and that's what's going to have to happen. Preventing Navajo from moving forward in this claim isn't going to keep that from happening, hopefully.
Yeah, just a quick thing. There was a couple points in the oral argument where the disconnect between what the justices thought was happening on the reservation and the amount of water was just really evident. And so there was that line of questions about what about the per capita amount, and do we have any figures on the per capita? And then they said we could provide that. But if you go back to Arizona v. California, it was supposed to be about not that, right? The per capita, to me, it reflects that sort of concern about cases and always starting with the demographics. The same could be said about this per capita framing of the larger claim. And I think the challenge is we're in this drought period, and the comparator would be Utah recently got allocated water separate from this process, and tribes weren't consulted. There's litigation involving that right now. And it was not a big deal, but when Indians want it, it is a big deal.
Okay, jumping to somebody. Oh, sorry, Professor Fletcher, did you?
Oh, I thought of the third thing that I wanted to complain about in Department of Justice. The answer to the question, like, how is this going to affect other Indian tribes? And Department of Justice position is, don't let Navajo win because other tribes will want the same thing. This is our partner in Indian treaties in the United States. They owe a duty of protection to us. They owe a trust responsibility to Indians and tribes. This is their position, is don't help Navajo here because other tribes might also be assisted by a favorable decision. This is wildly unethical. I think that answers the last question there too.
Yeah.
Not only is it unethical, but it's really inconsistent with, some of the more recent pronouncements by the Biden administration. So you have to wonder, who is our trustee, right? Is it Department of Justice? Is it the trustee that's characterized by Department of Justice, or is it the trustee that's characterized by feel-good statements on, on the occasion of annual meetings with tribal leaders? But, which one do we identify as, real?
Okay, so turning to some of the questions from our audience, how does this case interact, if at all, with the never-ending Little Colorado River adjudication in Arizona Superior Court?
I don't even know where the Little Colorado River is.
Well, I think there were repeated references to that litigation. It's a basin adjudication for, a tributary of the Colorado River that runs through a portion of the Navajo Nation. Repeated references to that during the oral argument yesterday. I think it was established that the Little Colorado River is very important, but it's not going to be the source through which all of the needs of the Navajo Nation to water in Arizona will be met, through which those needs will be met. So it's important that the nation is there adjudicating its water rights to that particular water source. But, it's not the answer, and it's not going to end the needs that are being, that I guess the issue that the nation is trying to move forward with in this litigation.
Yeah, my only thought, this is going back to the oral argument, they had the not the back and forth, but this position, look at how much money we've already spent and we're doing through these settlements. But then when you actually look at what they said, it was relatively insignificant for the scale of the problem, right? So they wanted to say, we're doing something, essentially they were arguing, trust us because look, we're already doing some stuff. But then the stuff they identify is so short of what's required that it should be read the opposite way, that you can't trust us because this is all we're doing.
Going into a little more nuance, there was mention of groundwater in the oral arguments. What does groundwater, specifically as recognized in the Agua Caliente case in the Ninth Circuit, how does groundwater play a role in this case?
Well, having worked on Agua Caliente in my former life as an ARF attorney, looking at what was established through the Ninth Circuit decision in that case, it was established that groundwater can be a source through which reserved rights are fulfilled for an Indian tribe, in a nutshell. And what the nation, as I read the third amended complaint that's proposed, is asking for is for the United States to go through a process through which they examine all potential sources through which their water needs can be met. So the rights recognized in Agua Caliente could be a consideration of the process, the actions, the studies, the reports that would be generated through, what the nation is seeking to have the US government do in this case.
Yeah, my only thing to say, I'm with Matthew on this, that's just a BS line that they did in the oral argument. I think and the tribe's position that Heather just said, granted, let's count it all. I think it's a very good response to that BS line. I think one thing that we mentioned, I think briefly in this, was that, the stuff on Hopi there is experience of what to do with groundwater, and tribes lose because their interests are not taken into account. And so the drying up and attached in connection with Black Mesa is a warning sign about reading too far into the groundwater and also the limits of groundwater compared to other sources.
Going into a little bit about the water quality, we talked a little bit about the arsenic levels in groundwater and, drilling wells generally. How much of the federal government's involvement in poisoning the nation's groundwater through uranium mines present in this case? And what are your thoughts about that aspect of the situation? Another kind of related question that was brought up in the audience is water quality part of the analysis in winters?
Go ahead, Heather.
No, why don't you go ahead and I think you're probably.
Okay, I'll say a couple things. So a water quality can certainly, and Matthew's going to know this much more than me, but water quality has been in some of the water claims. The one that I'm most familiar with was a professor at Georgetown that looked at water quality as far as the temperature of the water for other sources and how that connected with the volume of the water. But on Navajo, the challenge, and Ethel Branch was involved in some of this on one of that spill that happened in Durango and then came down the river. And certainly when it comes to uranium, we just don't know or pay attention to this. So, in the book, one of the examples that I give on the uranium is they let people build their houses out of uranium tailings. So you were literally sleeping on uranium, and the Superfund process is just so slow, and the amount of funding that's being dedicated to it is so inadequate to the number of abandoned mines that, of course, there's going to be follow-up and problems in the groundwater in those areas. But it would be enough, I think, in this case. I don't know that you want to mess it up too much because there's the ask is so small, it doesn't even have to get to that for in this case. So I think it's all relevant. The water's bad. The U.S. had a bad role, and there's a bad history of colonialism tied to the uranium mining on the reservation. But it's also a present wrong. We don't necessarily have to go to the past to see the wrong. We can see the present wrong in denying the water rights today.
Right. And I was just going to follow up to that to say that, the precedent is still developing as far as the extent to which quality is a component of winner's right. Again, it seems like a really basic common sense proposition, right? But getting a court to rule about to what extent water quality is part of water rights is something that I think is still under development. We have some very helpful lower court opinions about the requirements for water to be fit for the purpose for which a reservation is created and the water needs there. But the Supreme Court itself hasn't really ruled on that issue, at least not in the context of Indian water rights.
Yeah, there are some good cases from the US v. Washington litigation. At least one judge said there's more to the off-reservation implied fishing rights than the ability to dip your net into the water only for it to come up empty. That's what the US is trying to say here is if there's no water on your reservation, then too bad, so sad. You can't make us do anything, which is, obviously the tribe is not getting the benefit of any bargain there.
Jumping back to some of the questions that the justices had asked, we have an audience member who's asking, did it seem like Justice Jackson didn't like any of the first in time water priority claim arguments?
Maybe she's an Easterner like me and thinks Western water law makes no sense.
I felt like there was some disconnect in the questions and an understanding of Western water law for sure. And, the ways in which priority of uses was characterized, or maybe those questions weren't really answered in a straightforward way that's consistent with the doctrine of first in time, first in right, and some of those basic concepts of Western water law. I think there was a little bit of space between what the law says and the way that the questions were framed that made it really hard for especially the nation's advocate to sort of explain what it would look like in execution.
Yeah, I had a similar on the amount of explanation that was needed was surprising in some ways. I think the challenge is that, from the anti-Indian side believes that they're first in time because they're using it first, but that's not what's supposed to drive this. And so they're separating that out between what the law says, which is pretty clear on the Navajo side, and what's actually happening, which is that non-Indians are getting the advantage of the use and have for a fairly long time. That creates a seeming split, but it's only seeming split. It's not an actual problem.
Yeah, and I just want to follow up and give a shout out to my co-authors on our brief that focused on the Winter's Doctrine and on Western water law and sort of the framework of water management in the American West. Professors Dillon, Hedden Nicely, and Professors Monty Mills. Early on after the CERT grant, we decided that we wanted to write a brief together to focus on winters as law professors who are also former water law practitioners in the American West. We thought that we could make a contribution that way. And I just want to acknowledge the amazing work that they all did on the brief that we filed, as well as our students.
Okay, there seem to be a lot of questions relating to how the Navajo Nation or any advice or guidance to the Navajo Nation on how to react and leadership. I don't know if anybody has seen the press release that went out on Monday from the Coalition of Large Tribes that calls for action after the U.S. Department of Justice argues the U.S. Supreme Court that the Navajo Nation's treaty reserve water rights are basically meaningless. Any kind of thoughts on how what can be done, or any other kind of suggestions on basically how to work with the Biden administration or push the administration to be a little more supportive of tribal water rights?
So I'll start with this one. My answer to this is not about the administration. It's more of and not even about the law. It's a realist perspective on water. And I would say, get the water, right? So in a prior appropriation regime, we have the real concern is the non-Indian population is going to continue to grow and continue to treat, because CAP makes that so, that they can treat water as an insignificant expense for Southern Arizona. The Navajo Nation should do all it can to grab water while there's still some play in the system. I mean, the problem is, as the drought continues, the play in the system is diminishing, right? So the Western Water amicus brief says every gallon for gallon that Navajo wins is going to come against Southern Arizona. But if the federal position is, it's there, Navajos, just take it. We won't provide support, but take it. Then I would say, to the degree to which you have CARES Act funding or other sorts of funding, take it and do so quickly.
I think there needs to be a fundamental reconception of what water is used for, who's entitled to it. Western water law is a suicide pact, and so we're seeing that right now. I mean, really what Arizona is saying is all those golf courses open in Phoenix and Tucson are more important than people at Navajo having safe drinking water. That's fundamentally what this is at issue. I mean, they're going to say that they have, the Central Arizona Project, I know you brought that up, Ezra. What a joke. When they opened it up, it destroyed the entire plumbing system of the city of Tucson way back in the 80s. I mean, all of this is fundamentally wrong. Everything that is going on with water in these areas. And, this is a property rights government. It's a property rights constitution, and somebody has something, they're entitled to keep it no matter what, no matter how awful and nuisance laden these uses are, and we're stuck with it. There's just nothing to be done. I agree with Ezra though. If the Navajo's got money, and I know they do, go get some water. Make sure you don't come to the Great Lakes and take ours, because we like our water. I heard that in oral argument yesterday. That's some bullshit right there.
Right. I think it's important too, just to acknowledge that those tribes who have quantified water rights under the terms of water rights settlements, especially in the Southwest, have been able to make use of that water before they can use it on the ground, before they can put it to beneficial use on the reservations, because the infrastructure is still under development or for other reasons. they've been willing to offset the shortages in their surrounding communities in ways that have been really meaningful and really important to soften the blow of the water conservation measures that are going to have to be implemented in cities like Phoenix and Tucson and other areas of the Southwest. You have some tribes that have been incredibly helpful to non-Indians around them who don't have the water that they need to continue living the way they have been, and to sort of soften again the shock of cutting back in ways that really have to happen. So to me, recognizing increased rights by tribes to water can be helpful to these states. Maybe Arizona should be trying to advocate for the Navajo Nation to have the greatest water right possible, because bringing more water into Arizona could be a good thing for everybody. Maybe that's incredibly unrealistic, but maybe there's something to that. Maybe they're completely wrong-headed in their approach. They're cutting off their nose to spite their face in some ways.
We kind of talked a lot about how the tribe should, just work on getting their water. And in the oral arguments, we heard a lot of discussion about, well, this is going to bring up the whole aspect of bringing pipes. And the Navajo Nation is going to start asking for pipes. One of our questions in the chat is, under winter. So the question is, the Winters Doctrine includes a right to water, but no obligation to fund water infrastructure or do anything to help Native communities actually benefiting the water to which they are entitled. How do you think that will factor into the debates, considering how expensive it is to build water infrastructure?
Well, as I think you heard the Navajo Nation's attorney answer that question when it was asked, essentially was that those are issues that are usually settled and addressed through the terms of an Indian water rights settlement, that the infrastructure that's needed to put the water to use isn't going to be funded through litigation, through a judgment quantifying water rights in a bare quantification or decree to use water. It's through a settlement in which some concessions are made and water is made available, and the infrastructure to put the water to use and meet the needs of the people then is funded and constructed. So that's usually done through the terms of a settlement.
Yeah, mine was a similar point, is that, there's one of the questions in the Q&A was about what does it mean if it's all procedural and it's in advance? And I think it does go, as Heather's answer was, it moves the starting point for negotiation, or moves the relative power in the negotiation. And here we're talking about a really easy thing, like what can we agree as a starting point that Navajo needs are, and should the United States participate in discovering what those needs are? And that's really all the tribe is asking for at this stage. That should be, and I think that would be pro-Navajo, which is why it's being fought, but that should be a basic thing. This is an aside, but Mika and I went to the same school for a while, and that school, the thing I most remember is playing soccer on the field that was done with wastewater. So they would spread septic on the field, and the kids would literally be sliding in septic that smelled like septic. That is just, I'll just say, where I am now in Virginia, that would not be acceptable, right? And we have to get the idea that all of this is not acceptable. And it's no matter what the law says, the people should care enough to decide that Navajos too deserve water.
All right, it looks like we are running up to our end of time. Thank you all so much. One kind of last question that we'd love to hear from everybody about is, has this case provided any enlightenment or links to other Indian law issues, recent or pending?
I don't think so. Like Brackeen's pending, and there's going to be another case next month on tribal sovereign immunity. I don't think this is the same thing, but it does really tell you, when you look at oral argument, the lineups, judicial methodologies, the claim that the court is a bunch of neutral judges, if there is such a claim anymore, absolutely false. That you see justices on the right completely advocating their claims to be neutral textualists in exchange for policy questions to protect those golf courses in Arizona.
My only thought is on the Hickorea part, and whether Hickorea is a one-off or not, this result could tell us something about that for those who care about the trust responsibility. But you know, there's a hope that this will minimize the damage of Hickorea. But
Yeah, I don't think I have much to add to what's already been said. It's a somewhat unique issue. It has strong ties to a regional controversy. The justices line up in based on the questions and oral argument seem to be consistent with recent arguments as well.
Okay, and with that, thank you all so much for tuning in. Thank you to our wonderful panelists for offering your expertise and sharing your knowledge with our folks. Thank you so much. And just as a quick note to Professor Fletcher, somebody did note, as a Jedi, take a look at the artwork of Stephen Paul Judd for your background.
I switched mine just in honor of that question.
Perfect. Thank you all again, and we appreciate your time. This will be recorded and posted on our Native Nations Law and Policy website. The recording will be made available for those who want to go back and listen to it again. Thank you all again. Bye.